Becerra versus San Carlos Apache Tribe. June 6, 2024. Chief Justice Roberts delivered the opinion of the court. The Indian Self-Determination and Education Assistance Act, hereafter called the Assistance Act, enables an Indian tribe to enter into contracts with the Indian Health Service to assume responsibility for administering the healthcare programs that the Indian Health Service would otherwise operate for the tribe. To fund the tribe's administration of such programs, the Indian Health Service must turn over to the tribe the appropriated funds the agency would have used to operate the programs, as well as an additional sum to cover contract support costs. These costs are administrative expenses incurred by the tribe that the Indian Health Service does not incur when it runs the programs, typically because the agency can rely on existing government resources unavailable to the tribe. The tribe may also collect funds due from third parties such as Medicare, Medicaid, and private insurers to help finance the program. The question before us is whether the Assistance Act requires the Indian Health Service to pay contract support costs to support tribal programs funded by such third-party payments. In 1975, Congress passed the Assistance Act to promote effective and meaningful participation by the Indian people in the planning, conduct, and administration of federal healthcare programs. Such programs provide, for instance, hospitals, dental clinics, and ambulance services. After the Assistance Act enactment, a tribe can either continue receiving healthcare services directly from the federal government through the Indian Health Service, or it can assume responsibility for administering those services itself. If a tribe elects the latter route, the Assistance Act obligates the Indian Health Service to enter into a self-determination contract with the tribe. Under this contract, the tribe receives funds to operate federal healthcare programs that the Indian Health Service previously operated for the tribe's members. When the Indian Health Service administers healthcare programs itself, it funds its operations through congressional appropriations and third-party insurance payments. Historically, the Indian Health Service funding came from monies as Congress may from time to time appropriate. But in 1976, Congress enacted the Indian Healthcare Improvement Act, hereafter the Health Improvement Act, to create greater parity between the Indian Health Service and other healthcare providers. After the Health Improvement Act, when the Indian Health Service provides healthcare services to a tribal member with Medicare, Medicaid, or private insurance coverage, the Indian Health Service may collect the funds due from those third-party insurers for the services provided to the insured tribal member. Third-party payments now represent a significant portion of the Indian Health Service tribal healthcare budget, over $1.8 billion in 2024 alone. Healthcare programs, administered by tribes under self-determination contracts, have a parallel funding structure. First, the Indian Health Service provides to the tribes the appropriated funds that the Indian Health Service would have used to operate such programs absent the self-determination contract. The Assistance Act specifies that this sum, called the secretarial amount, shall not be less than the Secretary of Health and Human Services would have otherwise allocated for the operation of the programs during the period covered by the contract. Second, like the Indian Health Service when it runs the healthcare programs, contracting tribes can collect revenue from third-party payers like Medicare, Medicaid, and private insurers. The Assistance Act calls the funds received from third-party payers program income and requires that tribes use those funds to further the general purposes of the contract with the Indian Health Services. Just as third-party collections are not considered in determining the Indian Health Service appropriations, Congress has specified that a tribe's program income shall not be a basis for reducing the secretarial amount. The secretarial amount from the Indian Health Service and program income from third-party payers do not, however, place contracting tribes on equal footing with the Indian Health Service tribes, incur overhead and administrative expenses that the Indian Health Service does not incur when it runs the healthcare programs. For example, as a federal agency, the Indian Health Service does not have to pay state-mandated workers' compensation on the salaries of its doctors, but the tribes do. The Indian Health Service can also rely on other federal agencies, such as the Office of Personnel Management, for general administrative functions, but the tribes cannot. They have to manage on their own dime the auditing, insurance, financial, personnel, and other management systems associated with providing healthcare under self-determination contracts. To address this systematic shortfall in funding, Congress amended the Assistance Act to account for contract support costs. The Indian Health Service is now required to cover such reasonable costs for activities, which must be carried on by a tribe, as a contractor, to ensure compliance with the terms of the self-determination contract. Contract support costs eligible for repayment include direct program expenses for the operation of the federal program and any additional administrative or overhead expense incurred by the tribe in connection with the operation of the federal program, function, service, or activity pursuant to the contract. These categories of contract support costs are recoverable so long as they do not duplicate any funding provided through the secretarial amount. Contract support costs are limited, however, to costs directly attributable to self-determination contracts, and no funds are available for costs associated with any contract entered into between a tribe and any entity other than the Indian Health Service. These cases involve self-determination contracts between the Indian Health Service and two tribes, the San Carlos Apache tribe and the Northern Arapaho tribe. The San Carlos Apache tribe is located on the San Carlos Apache Indian Reservation, which was established in 1871 and encompasses 1.8 million acres spanning 3 counties in southeastern Arizona. In 2011, the tribe entered into a 3-year self-determination contract with the Indian Health Service. The tribe agreed to assume control of and manage it. The Community Health Representative Program, Emergency Medical Services Program, Alcohol and Substance Abuse Program, Behavioral Health Services Program, Teen Wellness Program, and Health and Human Services. In separate annual funding agreements incorporated into the contract, the parties specified the amount of funds due from the Indian Health Service to the tribe each year. The funding agreements included a scope of work attachment that described the activities the contract required the tribe to perform. The required activities included, among other things, maintaining an efficient billing system to maximize third-party revenues from Medicare, Medicaid, private insurance, and the Indian Health Service contract health services, and generating maximum third-party revenues for all eligible patient transports. In 2019, the tribe sued the government for breach of contract. As relevant, the tribe contended that although it used both the secretarial amount and program income to operate its healthcare programs under the self-determination contract, the Indian Health Service failed to pay contract support costs for the tribe's healthcare services to the extent they were funded by program income. The tribe sought roughly $3 million in unpaid contract support costs for the 3-year contract. The district court dismissed the tribe's claim, observing that the Assistance Act contract support cost provisions in Section 5325A do not mention third-party revenue. The Ninth Circuit reversed and remanded. It reasoned that the tribe's self-determination contract incorporated the Assistance Act, which required the tribe to spend third-party program income on healthcare. Those portions of the tribe's healthcare programs funded by third-party income thus constituted activities which must be carried on by the tribe as a contractor to ensure compliance with the terms of the contract. 5325A2 and the contract support costs associated with those activities were incurred in connection with the operation of the federal program. 5325I. The text of the Assistance Act, the court reasoned, therefore indicated that the Indian Health Service was required to reimburse the tribe for those costs. The Ninth Circuit stated that, at the very least, it could not conclude that 5325A unambiguously excludes the third-party revenue-funded portions of the tribe's healthcare program from contract support cost reimbursement. Emphasis deleted. The court was also unable to conclude that Section 5326 unambiguously meant that spending of third-party insurance receipts was not directly attributable to the tribe's self-determination contract. Based on these ambiguities, the Ninth Circuit applied the Indian canon and construed the statute in the tribe's favor. The Northern Arapaho tribe resides on the Wind River Reservation, which covers more than 2.2 million acres in west-central Wyoming. In 2016, the tribe entered into a self-determination contract with the Indian Health Service to assume control of the reservation's health division, the Wind River Family and Community Health Care System. Like the San Carlos Apache tribe's contract, the Northern Arapaho tribe's contract also incorporated an annual funding agreement and a scope of work attachment. Among other things, the scope of work specified that the tribe would employ experienced individuals, such as third-party claim specialists, in a financial office, bill and collect insurance and third-party receivables, maintain accreditation standards in order to qualify for funds through third-party payers, secure Medicare and Medicaid numbers for billing purposes, meet requirements for periodic renewal of accreditation or certification to maintain eligibility for these funds, use the Indian Health Service third-party billing system for 1 year to give the tribe time to set up its own functioning third-party billing system, and conduct quality assurance and all third-party billing processes. In 2021, the tribe sued the government for damages and declaratory relief. As relevant, the tribe alleged that, pursuant to the contract's requirements, it had collected third-party revenues and spent them to provide healthcare services, yet the Indian Health Service had paid no contract support costs for services funded by such program income. The tribe averred that it spent all of its program income on activities enumerated in the scope of work, so the income was spent as part of the federal program carried out by the tribe under the contract. The tribe thus contended that Section 5325A3A required payment of contract support costs related to the spending of those funds. It sought approximately $1.5 million in damages for the 2-year period at issue. The district court dismissed the complaint. A divided panel of the 10th Circuit reversed, with each of the 3 judges writing separately. Judge Moritz voted to reverse because the relevant statutory provisions are ambiguous, and the Indian canon of statutory construction resolves the ambiguity in the tribe's favor. Judge Ade also voted to reverse, but in her view the statute unambiguously supported the tribe's interpretation. Judge Baldock dissented in part. Although he also viewed the tribe's contract support costs as reimbursable under Section 5325A, he would nonetheless have affirmed the district court based on the superseding provision of Section 5326. We granted certiorari in both cases. It is undisputed that the Indian Health Service must pay the tribes the secretarial amount and the contract support costs associated with spending that amount to operate the healthcare programs they assumed from the Indian Health Service. It is also undisputed that the tribe's contracts require them to collect program income, and that the Indian Health Service must cover the cost of collecting that income. The only question is whether the Indian Health Service must also cover the contract support costs the tribes incur when they spend program income on the healthcare programs. The Assistance Act provisions that govern the amount the Indian Health Service must pay as contract support costs under a self-determination contract are Sections 5325, 2, and A. Both provisions peg the amount to the requirements of the contract. Because a self-determination contract requires a tribe to spend program income to further the programs transferred to it in the contract, these provisions require the Indian Health Service to pay contract support costs when a tribe does so, just as the Indian Health Service must pay contract support costs to support a tribe's spending of the secretarial amount. Section 5325A 2 defines contract support costs as consisting of the reasonable costs for activities which must be carried on by a tribal organization as a contractor to ensure compliance with the terms of the contract. The touchstone for determining which activities must receive contract support costs is therefore the terms of the contract. It follows that if a tribe must collect and spend program income to ensure compliance with its contract, then the reasonable administrative and overhead costs it incurs in doing so are contract support costs under Section 5325A2. The tribe's contracts and the Assistance Act plainly require them to collect program income and spend it to comply with their contract. Each self-determination contract entered into under the Assistance Act must contain the provisions of the model agreement set forth in Section 5329 CA. The model agreement incorporates into the contract the provisions of Title I of the Assistance Act. Title I of the Assistance Act includes Section 5325M1, which requires tribes to use program income earned in the course of carrying out a self-determination contract to further the general purposes of the contract. The purposes of the contract are no mystery. The model agreement requires that each self-determination contract include a purpose clause listing the functions, services, activities, and programs to be transferred from the Indian Health Service to the tribe. Tribes are thus contractually required to use program income to further the functions, services, activities, and programs transferred to them in their contract. When they do so and incur reasonable costs for required support services, those costs are contract support costs under Section 5325A2. In addition to satisfying the definition set forth in Section 5325A2, those costs are also eligible costs for the purposes of receiving funding under Section 5325A. That provision specifies two types of reasonable and allowable costs that may be reimbursed. First, direct program expenses for the operation of the federal program that is the subject of the contract are covered. Direct contract support costs include the support expenses of particular programs such as workers' compensation insurance for ambulance drivers or training for emergency room nurses. Second, any additional administrative or other expense incurred by the governing body of the tribe and any overhead expense incurred by the tribal contractor in connection with the operation of the federal program, function, service, or activity pursuant to the contract are also eligible for funding. Such indirect contract support costs encompass expenses that benefit multiple programs, such as auditing infrastructure, personnel systems, and legal services. Direct contract support costs incurred when using program income are covered because the functions, services, activities, and programs that a tribe agrees to administer in the Indian Health Service instead under a self-determination contract constitute the federal program that is the subject of the contract. When the Indian Health Service administers the federal program for the tribe's members, it uses congressional appropriations and third-party insurance payments to do so. The Indian Health Service must use the third-party collections to provide healthcare services. So the Indian Health Service federal program comprises congressionally funded and third-party funded healthcare. When that program is transferred to the tribe from the Indian Health Service, the tribe, rather than the Indian Health Service, becomes the entity collecting program income and spending it on the federal program. The tribe's resultant direct contract support costs are incurred for the operation of the federal program that is the subject of the contract. Those costs are thus eligible to receive funding under Section 5325AI. Indirect contract support costs that result from spending program income must be covered by the Indian Health Service for the same reason. A tribe's self-determination contract requires it to spend program income on furthering the federal programs, functions, services, or activities it assumes from the Indian Health Service when the tribe does so, as the Indian Health Service did when it operated the program, function, service, or activity and incurs administrative and overhead expenses. Those expenses are incurred in connection with the operation of the federal program, function, service, or activity pursuant to the contract. Such expenses are thus eligible for reimbursement under Section 5325A, 3A, The self-determination contracts of the San Carlos Apache tribe and the Northern Arapaho tribe go to some length to require them to collect program income by maintaining third-party billing systems and generating maximum third-party revenue. Once the tribes collect third-party income, they must use it. The tribes aver that they have collected and spent program income as required by their contracts to carry out the operations the Indian Health Service transferred to them. The reasonable direct and indirect contract support costs they incurred as a result are eligible for repayment under Section 5325A because they were incurred to ensure compliance with the terms of the contract and for the operation of and in connection with the operation of the federal program they assumed from the Indian Health Service. The Indian Health Service obligation to pay contract support costs is limited by Section 5326, but the limitations of that provision do not preclude payment of costs incurred by the required spending of program income under a self-determination contract. Section 5326 requires that the Indian Health Service pay contract support costs only for costs directly attributable to contracts pursuant to the Assistance Act. It further provides that no funds shall be available for any contract support costs or indirect costs associated with any contract, grant, cooperative agreement, self-governance, compact, or funding agreement entered into between a tribe and any entity other than the Indian Health Service. When a tribe spends program income to further the healthcare programs it assumes from the Indian Health Service and incurs contract support costs, the costs it incurs are directly attributable to the self-determination contract. Contrary to the government's assertion, there is no extended chain of causation. The tribe's self-determination contracts require the collection of program income. The self-determination contracts then require the expenditure of program income, and the self-determination contracts govern the activities on which that income may be spent. The required contract support costs that result are directly attributable to the binding terms of the contract, nor are such costs associated with any contract between a tribe and a third party. Those costs are instead associated with the contract referred to in the phrase contract support costs. In other words, the costs are associated with the contract that requires the work that generates the costs of the self-determination contract. A tribe's contracts with third-party payers are quite different. A Medicare or Medicaid provider agreement, for example, does not generate contract support costs by specifying which healthcare services a tribe must provide. Rather, it simply serves as a predicate for the tribe to collect program income after it has already rendered services to a tribal member who is a Medicare or Medicaid beneficiary. And when a tribe bills a private insurance company for services rendered to an insured tribal member, the tribe might have no pre-existing and ongoing agreement with the insurance company at all. The history of Section 5326 confirms this analysis. Congress enacted this provision in 1998 after the Tenth Circuit's decision in Rama Navajo Chapter versus Lujan. Rama involved a tribe that had self-determination contracts with the Bureau of Indian Affairs. For various programs, including law enforcement, and separate contracts with the state of New Mexico for criminal justice and juvenile offender restitution programs. The Tenth Circuit held that the Bureau of Indian Affairs was required to pay the tribe's full indirect contract support costs, not only for the programs administered under the Bureau of Indian Affairs contract, but also for those administered under the state contract. The government and the tribes agree that Congress added Section 5326 to override RAMA and clarify that the Indian Health Service may not pay costs incurred to support the Assistance Act contract. The direct attribution and association problems present in RAMA are not implicated here. In Rama, the state contracts, not the Bureau of Indian Affairs contracts, required the activities that resulted in the contract support costs for the criminal justice and juvenile offender restitution programs. Although those costs might have had an attenuated relation to the programs operated under the Bureau of Indian Affairs contracts, they were directly attributable to and associated with the state contract, not the Bureau of Indian Affairs self-determination contracts. Here, the self-determination contract itself requires tribes to spend program income to further healthcare programming. The contract support costs tribes incur when they do so are recoverable under Sections 5325A and 5326. The government's arguments to the contrary find no support in the Assistance Act text. The government begins with the premise that the Section 5325A2 requirement to pay contract support costs is tied to the Section 5325.325, but nothing in Section 5325A2 suggests that contract support costs are limited to programs funded by the secretarial amount. In fact, Section 5325A2 defines contract support costs as tied to the terms of the contract, which require tribes to fund programs with program income. The government then attempts to extend its flawed premise to Section 5325A3, asserting that the contract support costs of spending program income are ineligible for repayment under that provision, because the federal program comprises only the secretarial amount. But besides reciting Section 5325A, 3A, the government cites no statutory text to support this assertion. And Section 5325A, 3A, refers to eligible costs for the operation of the federal program without limiting that program to the secretarial amount. Leaving the text behind, the government argues that the tribes should not get contract support costs for spending program income, because that would give them the flexibility to spend such income on a broader range of activities than the Indian Health Service can. But none of the government's cited differences withstand scrutiny. First, the government says that the Indian Health Service cannot offer healthcare services to non-Indians unless the beneficiary tribe requests it, whereas a tribe running its own programs can unilaterally decide to offer such services. This difference is irrelevant. Before either the Indian Health Service or a contracting tribe may offer healthcare services to non-Indians, both must make the same determination: whether such services will result in a denial or diminution of services to eligible Indian. And the fact that the contracting tribe can act unilaterally in this regard is the natural result of self-determination. Next, the government says that when the Indian Health Service collects Medicare and Medicaid proceeds, it must first use such proceeds to ensure compliance with those programs. But tribes also have to ensure compliance with Medicare and Medicaid requirements using program income. Finally, the government contends that while Congress has prohibited the Indian Health Service from using Medicare and Medicaid proceeds to construct new facilities, tribes do not face this prohibition and thereby have greater ability to expand their operation. But to the extent that a tribe expands its programs beyond the federal program, the Indian Health Service would not have to pay contract support costs for the tribe's new programs. Even if there are minor differences between what the Indian Health Service and tribes can do with program income, that should not be surprising, given the Assistance Act designed to provide tribes greater flexibility in planning and implementing healthcare programs attuned to the needs of their communities. The government points to nothing in the Assistance Act text to suggest that those differences excuse the Indian Health Service from paying contract support costs when tribes spend program income on the programs they have assumed from the Indian Health Service. As for the dissent, its central assertion is that the support costs tribes incur when they spend program income are not incurred in the performance of their contracts, but the tribe's contracts plainly require them to collect income from third-party insurers. And by incorporating Section 5325M1, self-determination contracts plainly require tribes to use that income to further the general purposes of their contract. The dissent complains that the contracts do not address how the tribes must spend their third-party income. But as we have explained, the purpose clause of each contract describes the programs which tribes must further using program income. The support costs tribes incur when they do so are incurred in the performance of their contracts to ensure compliance with the terms of their contracts. And those costs are directly attributable to and associated with tribes' self-determination contracts. Obfuscating the straightforward reading of the relevant Assistance Act provisions, the dissent points to Section 5388J and the costliness of the Assistance Act mandate. But Section 5388J does not apply to self-determination contracts, and complaints about costs are the domain of Congress, not this court. Aside from being inconsistent with the statute's text, the Indian Health Service failure to cover contract support costs for healthcare funded by program income inflicts a penalty on tribes for opting in favor of greater self-determination. Congress designed the statute to avoid such a counterproductive result. Underlying the Assistance Act was a congressional finding that federal domination of Indian service programs had denied tribes an effective voice in the planning and implementation of programs responsive to the true needs of their community. Congress thus designed the Assistance Act to promote maximum Indian participation in the administration of healthcare programs. To that end, Congress's consistent directive to the Indian Health Service is to place contracting tribes in the same financial position as the Indian Health Service, so that tribes do not face a self-determination penalty when they take control of their own health care. When tribes enter into self-determination contracts and assume control of the Indian Health Service programs, they receive the same amount of congressionally appropriated funds to run the programs as the Indian Health Service would have. Congress also allows tribes, like the Indian Health Service, to fund the programs with income from third-party payers. To be clear, the Indian Health Service needs to collect these funds just to cover its obligations to tribal members. Indeed, 60% or more of the yearly budget of some the Indian Health Service healthcare facilities relies on third-party revenues. Like the Indian Health Service, tribes choosing self-determination in healthcare need to collect and spend program income if they are to maintain the same level of services they receive from the Indian Health Services they received from the Indian Health Services. For that reason, Congress specifically instructed the Indian Health Service that program income shall not be a basis for reducing a tribe's secretarial amount. Contract support costs are necessary to prevent a funding gap between tribes and the Indian Health Service by definition. These are costs that the Indian Health Service does not incur when it provides health care services funded by congressional appropriations and third-party income. But they are costs that tribes must bear when they provide, on their own, healthcare services funded by the secretarial amount and program income. If the Indian Health Service does not cover costs to support a tribe's expenditure of program income, the tribe would have to divert some program income to pay such costs, or it would have to pay them out of its own pocket. Either way, the tribe would face a systemic funding shortfall relative to the Indian Health Service, a penalty for pursuing self-determination. The self-determination contracts of the San Carlos Apache tribe and Northern Arapaho tribe require them to collect and spend program income to further the functions, services, activities, and programs transferred to them from the Indian Health Service when the tribes do so and incur administrative costs. The Assistance Act requires the Indian Health Service to pay those support costs. The judgments of the Courts of Appeals for the Ninth and Tenth Circuits are affirmed.